myself. My name is Nevena Krivokapić-Martinović, and I'm the Price Media Law Moot Court Coordinator. Together with me are my colleagues Sanja and Sarah today, and we are very, very glad that we are able to welcome you to our first event around the moot for this extraordinary year. Usually we do this Mooting Masterclass in Oxford for our first day, but here we are at the end of the November doing it, which I think is great for teams and participants this year. And this is just one of the events that we are going to be doing throughout the year. And thank you all for joining us. We will also be recording this event so we can publish it later on for everybody who are not able to join us today. I'm very pleased to announce our colleague Raphael today that is going to give you the Mooting Masterclass. Raphael, and the most important thing to mention at the beginning is alumni of the Price Moot court competition. He won the international rounds in 2015, and I think that's the biggest experience that he can share with you today. Also, he's a lawyer from Philippines with criminal law and human rights experience, and he has finished his law studies within the University of Philippines, American University, the University of Oxford, and the University of Cambridge. He sits as Associate Dean and Assistant Professor in Human Rights of Jindal Global Law School currently. I'm not going to talk too much. I'm just going to give the floor to Raphael, and as well, he will give you a couple of instructions in regard to questions and so on. So Raphael, the floor is yours.
Well, Nevena, thank you so much for that kind introduction, and of course to the Oxford Price team organizing team for the invitation. I've always been very happy to pay things forward in a sense. Oxford Price was a defining moment in my JD student life, and I'm very happy to have a hand in this half a decade later. So yeah, before we dive into things, I'd like to first of all welcome all of our mooters from around the globe. Welcome to the Oxford Price Moot, and I'll be speaking to you about a few tips, the tricks of the trade that I've learned over the years from my different capacities in the moot world. As Nevena had mentioned earlier, I had joined Oxford Price myself, so I know exactly how you feel. May your role be as an oralist or as a researcher, but I would like to add as well that even beyond my student days, I remained active in the moot as a coach of the University of the Philippines, as a judge for particular moots, and most recently as the coach of the University of Cambridge moot court team, to much success, if I may say so myself. So what we'll do is, and what I would like to suggest for us is this. In case you have any questions along the way, and I understand that these queries, these interests, they may be very spur of the moment things. What we can do is, I would like to invite you to type out your questions in the chat box, where Sanja has just dropped a message welcoming all of us as well. And feel free to plug in your questions anytime. And at the end of this presentation, I can go through this list and address your questions one by one. Now, of course, at the end, and I understand there's a thought process here as well, and some people may prefer to leave their questions to the end. Feel free to chime in then as well. You can type it out in the chat box. You can raise your hand, and when we call your name, you can turn on your microphone and ask your question orally. In a way, it can be, I imagine, a brief warm-up to the actual presentations, to the moot court presentations over the next week, next few weeks. Now, to the presentation itself. So, yes, I would like to first make sure that the PowerPoint is on. Yeah, thank you so much, Samia. Okay, give me 1 second to navigate. Okay, so yeah, so this is the Mooting Masterclass for 2020. And again, I'm Raphael, and I'm super happy to be here with you now. So I'm speaking with you from the Netherlands, from The Hague, thus the gloomy weather. And I would like to make up for that gloomy weather with the excitement and with the spirit reflected through the presentation itself. So this is indicated as a mooting masterclass, but I would otherwise refer to it as a presentation on how to win a moot. Sonia, if we could go to the next slide, please. Thank you. And as I mentioned earlier, I have had many different roles in the moot court scene. And I would like to, first of all, congratulate each and every one of you for deciding to join and step up to the plate, despite what has otherwise been a very hectic and unique year. We all join moots for different reasons, and allow me to cite the very practical ones. There are joining a moot is a very beneficial thing for students in terms of the subject matter expertise that you will garner over your training. And I think that this applies particularly and most especially for the Oxford Price Moot, which deals with issues that are at the heart of contention in this day and age. I mean, freedom of expression, I think, and perhaps I'm already preaching to the choir at this point, but freedom of expression is, I think, one of the most interesting human rights to explore. And with the way that the case problem has been drafted, it highlights particular issues, which is far from the abstract. It's things that we deal with day in and day out. We could read the newspaper and see this, and perhaps it just comes in different names. I understand that this year's problem deals with the novel immunodeficiency virus, which I think we don't need to stretch our imaginations to find, well, one way or another to relate with what we're reading. And I think that that is a quality of the Oxford Prize Moot, which makes it a world-renowned go-to competition, which students very much enjoy. And certainly I'm not just saying this having won the competition myself in 2015, but I mean, quite frankly, it is the participating that is the winning. And that old adage applies to the Oxford Prize. Absolutely. Now, when I recall when we were asked a few years back, it was half a decade ago when I joined the Oxford Prize Moot Court competition, and we were asked, what was the defining moment? How did you know that there was a special something about this problem? And I remember answering and telling the interviewer at the time that the problem we dealt with in the Oxford Prize case situation, and I remember it vividly, it was the case of Derek Kutik and Digitube. And imagine, just it's been half a decade and the memories are still fresh. What made it so easy to deal with and to engage with this was because to us it was real. This may have been a moot court, but that didn't mean that the issues were moot and academic as well. These were very real issues. The controversies between two religious groups, a majority and minority faith, and the limits of free expression. And it was by engaging with that advocacy that we were able to show the X factor. In the slide after this, you'll see the presentation flow. And what I will be addressing are, well, 5 points for you. First, on the modes of communication. Secondly, on issues of prioritization. Third, on engagement. Fourth, on dealings with questions. And fifth, strategies. And I have to tell you that the lessons that I derived from this mood and the lessons that I share with you now are, well, applicable, are relevant, and find their place, not only as student mooters, but in the legal practice as well. The analysis, the exercise, the camaraderie that is required to successfully go through this endeavor is something that goes beyond the moot court, that goes beyond your student lives. And I'm very happy to share with you that indeed my teammates at the time have turned out to be very good friends, some of whom ended up getting married to the other. So the moot court really does open the doors to all sorts of great things. So with that said, let me start with item number 1 on modes of communication. So first of all, when we're dealing with a moot, we're dealing with 2 types of modes. There's the oral presentation that we're about to engage in over the next few weeks, and there's the written submissions. And one thing we need to take note of is that the oral and the written are not one and the same thing. And this may seem pretty obvious to you, but it needs to be emphasized because each is not only, well, different in terms of vernacular, but also in the terms of their strengths, in the tools that are available to you. In footnote, in the written word, you have footnotes, you have spacing. While in oral presentations, you have the choice of volume, you have pacing. And what is available in one medium vis-a-vis the other, well, are different. And one of my favorite examples to illustrate the limits that the mediums provide is, I think, one of the most difficult things to write about, which is silence. Have you ever tried writing about a quiet moment, a silent pause? I think is rather difficult. It isn't impossible. And I think it takes true authorial skill to be able to pull that off. Yet when it comes to oral presentation, silence is not only, well, quite easy, but it is quite a useful tool. It is an extremely useful tool in oral argumentation when it comes to perhaps adding emphasis. A brief pause may indeed spell a difference because, well, sometimes less is more. Sometimes silence is key. And a subtle pause can make a world of difference when it comes to your presentation, because otherwise you'll be flooding the information, and that isn't the goal here. Yeah, so there are particular tools available to you as an oral presenter that isn't available when you're writing. There are the nonverbal cues, there is the body language, there is, well, the vibe when presenting. And one of the reasons why I had always been assigned to the applicant position was they felt that I would be, well, a bit too daunting if I had represented the government, or if I had represented the defense in other arguments. And the idea was, well, what we need is a particular image, the image of a victim. And perhaps my role and my actuations and the way that I present in general is more appropriate for one over the other, and to each their own. Now, each mode of presentation does have their benefits, but each has their burdens as well. The technicalities have an easier time being explained on paper. So you may have threshed out an argument through your written submissions, but in the oral presentation, you may not be able to present all of them, not only as a matter of time, but especially as from a consideration of what I would refer to as audibility. There are some presentations, there are some arguments that make sense on paper, and the technical arguments are often fine when read, but when said out loud would in so many words leave a bad taste in your mouth and may leave more questions than lead to more questions than answers. An example of this is, I remember when I was coaching my university in the University of the Philippines in the Leiden ICC Moot. And one of the arguments that had to be forwarded was whether there was a numerosity requirement in dealing with crimes against humanity. And while this is in, well, one way or another up for debate, I had to recommend, and I think it was a good call, for the defense counsel not to raise it, because while the argument on paper may have made sense, that there is in fact a debate on whether or not there is a numerosity requirement for the application of a particular doctrine, to argue that out loud would be to say that, oh, only an X number of people had been victims of a particular crime against humanity. And in the end, whether that argument is doctrinally correct, I think would be beside the point. Because in the end, the audience, the judge, or maybe third parties watching your presentation would just think, oh, okay, isn't that rather cruel? Isn't that rather callous? And the thing is, you can be correct, yet the callous argument doesn't win votes either. So that's a matter of, and that's why you need to pick and choose, which leads me to my second point. It is a question of prioritization. You need to prioritize, you need to pick and choose the arguments that you will be forwarding in your moot. Clearly, you shouldn't try to address it all. Not only is that impossible for the purposes of time, but it's strategically it wouldn't be the most strategic way of approaching the argument. As well, each of your arguments have their strong points and their weak points, and a good moot court problem is one that offers a balance between the two. Perhaps within one submission, or perhaps this one submission is leaning towards one side and the other. But what I do know is that the Oxford Prize Moot does provide very fair cases in which both the applicant and the respondent have a fair number of obstacles to hurdle and strengths to rely on. So it's a matter of highlighting those strengths. After all, why would you highlight your weakness? And oftentimes, when we deal with these questions, the tendency is to think that the other side doesn't matter, that the argument is wrong, completely wrong. And I invite you to guard against that sentiment. I mean, there are certain occasions where it can be invoked that the opposition, whatever your side, may have completely missed the point. There is room for that argument as well. But I think what is more enticing and what is more engaging isn't the argument that says, oh, they are completely wrong. It's the argument that says, oh, they may be right, but this isn't the particular case for it. It's a way of engaging with the problem. And I think one fine example of that, which I recommended to my teams as well, whenever I coach them, is when it comes to, for example, the role of the government. It is one matter. It is a particular way to say that the other party is wrong, that the arguments that they are hurling in your direction do not apply. But that would be to parry the argument. That would be merely to say that they are wrong, full stop, and therefore rule in my favor. And it doesn't quite work that way. There remains much space to be bridged. But rather than parrying, perhaps what you can do is embrace the argument and make it into your own. In every human rights moot, what I would train the defense counsels or the respondent agent to forward is, of course, the non-liability of the party they represent, the government. And what this would mean isn't only that the government does in fact respect human rights, because that's only a first level argument. That would be equivalent to parrying the argument hurled against you. I would invite you and I would recommend that you actually push things a bit further. It isn't enough to say that this particular regulation does not impair human rights, that it in fact abides by the three-part test and works within the obligation to respect. That's, I think, a good argument, a right argument, but a rather shallow argument. You can go deeper. And a way of going further is by saying that this isn't only a matter of respect. The regulation that the government has imposed is in fact pursuant to its obligation to protect, to fulfill. So the mindset really doesn't end with saying that, oh, the government are not bad guys, that the respondent is not an antagonist. Rather, the government is in fact the protagonist of this story. They are the heroes. Not only should accusations be withdrawn, an apology must be forwarded. The government should be saying, oh, you are welcome, because what I am doing is in fact pursuant to human rights. Because as we already know, as young human rights legal minds here, the obligations that states that human rights law imposes upon states are, well, tripartite. There's the respect, protect, fulfill, which take a negative and positive nature. And there's a way of playing within that framework to portray what the applicant would argue is a violation of human rights as in fact a tool for human rights. So I think that it's a matter of prioritizing which arguments and which ways you would be able to do that most successfully. Which leads me to the third slide, third point rather, thank you, which is engagement. Now, there are various ways to engage, various levels to engage when it comes to an oral presentation. Of course, there's engaging with your opponent, engaging with the debater at the other end of the room. In this case, at the other end of the Zoom room. And every speaker must make it a point to address their points directly, especially in the rebuttal and the surrebuttal. It is a lost opportunity to every speaker to simply rely on a prepared speech, to simply echo what was already said before. Each argument is unique. And in fact, to be able to qualify beyond the preliminaries, it is a matter of shining through. If you will merely be citing general rules and the go-to arguments that each and every person has forwarded, then how will you stand out? And of course, when engaging, in terms of engagement, the worst thing that a oral presenter could do is, well, read, to rely so heavily on the prepared speech that they would be catching eye contact with a piece of paper before them, rather than with the judges. The judges that they are in fact presenting their arguments to. Now things are a bit different, however, I admit, through when done through Moot, when done through Zoom. But there are ways of making this work in your favor as well. For example, one piece of advice, when I was coaching the University of Cambridge in the European Court of Human Rights Moot, the ELSA Moot Court competition, I had suggested, and I think it had worked, that they place their laptops, their cameras, below eye level. Because that way, when you catch eye contact between the lens or with the notes that you have on your screen, it isn't quite as obvious as compared to when your camera is leveled with your eyesight and every glance you make away from it is quite obvious. I mean, there are those aspects as well. Some speakers would present themselves in front of a single camera. And I understand that there will be 2 presenters per side. So while others worked with just having 1 camera each, largely depending on whether, well, they were in the same room. So there are those matters to work with. So there's engaging with the debater. And of course, there's also engaging with the debate, for there is indeed room for debate. This builds on something that I had mentioned earlier, which is acknowledging that what we are dealing with here is a controversy. It is a controversial question. It is a slippery question of law. And oftentimes, the hard line stance would fail to adequately address that controversy. It isn't simply, therefore, a matter of evading the points. It isn't simply a matter of denying, but a matter of engaging. I would like to compare the moot court presentation with a game of catch. But instead of hurling arguments against the other, and instead of passing baseballs from one another, what we're throwing are eggs. And how do you catch an egg? You don't simply just grab it. You don't simply just parry it. You absorb it. You absorb the full force of that argument. You don't resist it. You return it. The best way to address a controversial question is by cushioning it. If you fail to cushion it, just like an egg, you risk the chance of breaking it. So when engaging with these problems, rather than making that hard line stance and prancing along that lines of making it seem as if freedom of expression is an absolute rule, is an absolute right, recognize the fact that it isn't. Recognize that there are limits and deal with those fine nuances rather than from outside of it. With that said, to avoid the hard line stance, at times it is best to avoid the hard provisions. Don't mention the hard law expecting that that will be the answer. Rather, engage with the concept. It's something that arises as well in oral presentations more than written pieces. In written works, you can spell things out. Well, quite literally, you do spell things out. But as compared to an oral presentation, you need a handle. So another example, and forgive me for relying on other moots, but I'm making it a point to avoid the substance of the Oxford Price Moot. In the Jumping Thing, IHL Moot Court competition, rather than invoking Article so-and-so in additional protocol 1, perhaps we can refer to the concept, the principles of distinction, proportionality, etc., etc. And by referring to the concept, you give a handle, and you are able to communicate not only the text, but the entire narrative, which the judges should be able to recognize. After all, they were invited because of their expertise in that field. The goal is to show the judge that you know what you're talking about, that you are familiar with this concept, with this law, without having to read verbatim. I remember I made that mistake once in a moot court presentation where I began by saying Article 19 of the ICCPR, and I recited paragraph 1 verbatim, and the judge asked me, okay, so what does that mean? And it confirmed what I'm sharing with you now. If this was simply a matter of showing them that you know the text, well, then an email would have been sufficient. Perhaps a list of BuzzFeed bullet points would have sufficed. But no, what we're engaging with here are the fine nuances, the conceptual nuances of the moot. And in so doing, we are able to engage not only with the debater, not only with the debate, but with the judge, him or herself. And with that said, when the judge asks you a question, the challenge is to address that question directly, completely, and immediately. Do not postpone. Do not say, oh, I'm actually going to address this. Or my speaker number 2, respondent 2, will be the one to address this issue. No, the question has been asked here and now. Then address it here and now as well. There are various ways of engaging with the judge. There's, of course, the formal technicalities. I mean, make eye contact, which I think is less a strategy of debate and more good manners. But when it comes to the debate, don't look at a single judge. One mistake rookie debaters often make, rookie mooters often make, is that they focus simply on the president, as if the others don't exist. The challenge is to connect with the entirety, with the panel itself, which may range from 3 to 5 depending on, 3 or more depending on the round. In so doing, in the manner in which you do so, again, should be comfortable, should be in a way conversational, it should be fluid. You are presenting an idea to someone who is interested in knowing your idea. You're not trying to convince them that, oh, hey, you should listen to me. You're not pitching this isn't an elevator pitch when you're trying to win them over to buy that time. No, you have that time. You already have 15 to 20 minutes to present that argument. So make it fluid, make it conversational, make it relatable, make it memorable. When presenting each and every argument, always be, of course, credible. Be able to cite, be able to support. And you don't need to do so with every argument that you forward, but you need to be ready to be able to back your argument up with legal support. It is such an awkward moment in any presentation, not only for the speaker himself, but even for the audience, when the judge asks, what is your legal basis for that? And the speaker is unable to forward. It's like, oh God, that's quite a terrible moment and a defining moment as to who will win or who will walk away as the winner or the loser of that particular round. So it is very important to make sure that when presenting your arguments, you are prepared to back that up with legal support. After all, this isn't a reflection paper. This isn't a presentation of sentiments. Neither is this purely a question of advocacy. And we often need to draw a distinction between our advocacies and our function as a legal advocate. High passions have room in advocacies, but and you'll see this once you're lawyers, when it comes to the actual legal arguments, oftentimes the advocacies need to be tempered. The advocacies and the outer limits of these advocacies need to make way and play within a system of rules. You need to cite those arguments that actually work in your favor best. Further, when addressing the questions of judges, keep things simple. Be brief and to the point. Use simple words. You don't need to try to impress the judge with highfalutin language. Latin maxims may every now and then either be truly appreciated or or you will likewise risk witnessing eyes rolling. But what is important is that when you do invoke these concepts, when you invoke the article number, when you invoke the maxim, you do so deliberately, that there is a particular function. A Latin maxim, for example, may work its magic once in a presentation, maybe even twice. But if every single argument, if every single submission is presented through an article number, through a paragraph number, through the same case, there is a particular fatigue, there is a particular saturation to its force. So choose those, the invocation of these doctrines wisely. And last but not least, when engaging with the judge, of course, do not speak over them. Do not be frustrated and do not show, or if ever you do get flustered, do not show your frustration to the judge who is asking you a question, because oftentimes the mentality is, oh, this guy is trying to catch me off guard. They're trying to mislead me. They're trying to trick me. And I'm not saying that there aren't judges who do play that role. There are good cops, there are bad cops, and it's all role playing, really. But oftentimes questions are asked because sincerely there is a matter that is in need of clarification. So when that question is forwarded, rather than avoiding it like the plague, engage with it, address it, and be thankful for it. Because at that moment, the judge just told you, hey, this matter needs to be addressed. And if you're able to do so, you will, well, strengthen your argument one way or another. So take that as an opportunity to improve the argument rather than being frustrated with it, rather than guarding against it. Which leads me nicely to my next slide. On dealing with questions, you should invite them rather than avoid them. And what truly works for an oralist is not only to engage with the question, but to ask for them, to fish for them. Sometimes it's a matter of taking a pause and asking the panel, do you have questions that you would like to ask? And there have been occasions where not a single question was asked in my presentation. And that's always a scary moment because you're not quite sure why that is. And this is oftentimes the case for applicant one, who, because they're the first to present, the judges, the panel may be, well, warming up. So it's very important to give them the opportunity to ask the question. It shows confidence on your part. And to be honest, it likewise brings comfort. If giving them the opportunity, they say, oh, well, actually, I really don't have questions. It goes to show that, hey, maybe your presentation has been that clear, as compared to merely presenting not a single opportunity to raise a question and not a single question asked, and you leave that podium asking yourself, oh, what just happened? Giving them the opportunity would confirm, giving judges the opportunity, one way or another, confirms the status of your own presentation as well. One of the reasons as well that you should invite these questions is, well, it does justice. It does justice to the role of the judge, and it does justice to yourselves. You have been preparing for this moot for weeks or for months. And it is through these questions that your genius shines through. So do yourself justice and give justice to all that hard work by asking, by inviting questions, by accepting them, and by engaging with them. When answering the questions, the instinct is often to get them over and done with. Again, much like addressing the opposition, the instinct is to say, oh, no, that doesn't apply here. This question doesn't apply at all. But the question has been asked, so face it head on. Otherwise, the judge who just forwarded that question would feel shortchanged, would feel undervalued. They just forwarded what they thought was an important matter. So the least you could do is recognize that importance, recognize that relevance. Now, again, there's no perfect calibration for this. Oftentimes, it's an element of luck, it's an element of chance, but that is where preparation comes in. That is why you have had months to prepare for these arguments. Which leads me to my fifth and last point for this presentation. It comes down to strategies. And one of the most important strategies when it comes to oral presentations is this. If someone asks you how to win a moot, the answer is simple: clarity. There are over 100 participants in this presentation right now. And each one of you, I'm sure, is prepared and is in this to win it. And in that preparation, one way or another, you will rely on the same doctrines. You will be citing the same cases. And this is especially true when it comes to the qualifying rounds. After the preliminaries, each team that makes it through has pretty much been ratified. It has been confirmed that, oh, okay, you have the right theory. Your argument is correct. That's what that shows once you make it through. And at that point, the question, therefore, is no longer who is right, because that has been leveled. You wouldn't have got that far if you had been forwarding the wrong argument. It is at that point where it becomes a question more of style than substance. It becomes a question of clarity rather than content, because again, in terms of content, the field has been leveled. And when dealing with these presentations, when presenting the content, we are not asking you to reinvent the wheel. When addressing these questions, we are not asking you to solve the problems of the universe. We're asking you to address this case. We're asking you to represent your client. And the best way to do so is through an Occamian approach. Just keep things simple. Keep things structured. Simplicity, I think, is often reinforced with the way that you present these arguments, which is why I've always taught my teams and my students in my classes as well, that when presenting, whether in school, whether in practice, abide by the rule of three. Say what you're going to say it, and then summarize what you just said. And if you're able to signpost, present your argument, and summarize everything that you just said for the purpose of the reader, then you will be able to, for the listener, you will be able to communicate your point. Another tip that I have when it comes to the strategies is, again, the mental game. First of all, if you get nervous easily, that's fine. I want you to know that, may it be in sports or may it be in academic competitions, it was when I was most nervous that I was able to do best. And the reason for that is, well, simple. The jitters is, well, for me, and again, to each their own, confirmation that you know what you're getting yourself into. You know that this is something real. You know that this is something serious. As compared to someone who says, oh no, this is no issue whatsoever. So that's one when it comes to the mental game. Secondly, when deciding your role, it isn't enough to choose what arguments you'll be forwarding. You also need to choose your voice. Will you be the legal technocrat? Will you be the academician? Will you be the legal advocate? And oftentimes you can take away the strengths from the strengths of these respective roles. But it's very important to conceptualize how you want to be perceived by the judge. Otherwise, again, if this was purely a question of the content of your argument and not the clarity and the appreciation thereof, then there would be no need for oral arguments. Your written submissions would have sufficed. In fact, you did not have even submitted a written memorial. An enumeration of 20 bullet points probably would have been the best way to do so. But in order to get your idea across, but in order to be appreciated to its fullest, you also need to settle the manner that you will present and the way you want to be. You want the third persons to be viewing you as well. This comes down not only to the way that you present this, but your mannerisms, what you do with your hands, the facial expressions that you make. A tip that was given to me during my early mooting days by one of my senior teammates was that, well, practice in front of a mirror. See, or in front of a camera, in front of a recording, see how you look. When do you panic? When are you so clearly lost within your own ideas, which isn't necessarily a bad thing. Some truly epiphanic and ingenious moments come out during those moments. But, well, there are limits to it as well. And last but not least, and I think this is one of my most favorite pieces of advice that I give to young mooters, be deliberate, not only about the choices, not only over the choice of argument you forward, but the order in which these arguments are presented. Weak arguments have an exponential effect. Not only do they not work in your favor, they are distracting. They are remembered and they weaken the overall score, the overall strength of your presentation. But at the same time, there's also a way of improving the effect of the argument simply by reordering them. Oftentimes, my students would open by invoking the general rule, by invoking the presumption. The presumption is in favor of human rights. There is a pro homine presumption when we deal with these questions. And when you open with that argument, I, as a listener, I, as a judge, would think to myself, well, I'm not here to presume. I'm here to hear you. I'm here to hear your argument. So make your case. And all of a sudden, what is a real doctrine? What is actually a very useful doctrine? Turned into a premise that is taken for granted, turned into a premise that will be overlooked. As compared to keeping that doctrine in your back pocket and waiting for these issues to arise, arguing and engaging until you reach a point where you've reached a détente, where you're just floating there, and the question is, where should we lean towards? And that is when you invoke the presumption. In that situation, you will be able to deliberately and effectively use the pro homine presumption, or the general rules that we find throughout human rights law. There is a way, by reordering your argument, you can shift it from being a premise to a basis. And in so doing, what you forward isn't the doctrine as stage setting. You're not merely setting up the framework. You have made what was otherwise stage setting into a substantive argument in support of your claim. So these are, I think, a few very important strategies when presenting your oral arguments. Keep things simple, be clear, be structured, and be deliberate. Choose not only what to invoke, but when to invoke it. And if you're able to do so, I have no doubt that you will be forwarding a successful and winning argument. So that is the end of this very quick presentation, and I thank you so much for your attention thus far. And I guess now we can, we can open the floor to questions. So, Sonia, shall I just go through these and just address them one by one?
Yeah, that sounds good. We've got three questions in the chat. The first, you can either call upon the questioner to raise their question live, or you could directly address the question as they've described it in the chat. That's up to you.
I see. Okay. Let me just look. Okay, one question is, in some national jurisdictions, asking questions to judges is not considered appropriate. That's why advocates say, I ask myself, so how to invite for questions in such a situation? Well, thank you so much for this question, because it allows me the opportunity to clarify. You're not so much asking the judge a question. You're not asking them how a doctrine applies. What you are asking them is, do they have questions? That's it. That's the only question that you're allowed to ask the judge. You're not asking them to solve this issue for you. So I'm glad you've pointed this out, because I'm able to clarify that point. And in case you need me to elaborate further, just let me know. Second question, how do you suggest retaining or returning to our structure if we're thrown off by some of the questions, especially considering the time limit? Okay, now that is a very real challenge all mooters will face. And it is the best of mooters who will be able to address a question with something that they had already prepared. Now, this isn't to say that we should stick to our prepared speech. This is not to say that we need to stick to it verbatim, especially. That should be avoided. But rather, there is a way of addressing a question without having to digress from the points that we want to make. And if you're able to maneuver and counter-maneuver, to be able to address a judge's point while sticking within your flow, not only will that be a winning argument, it will be an impressive one. The judges will be able to tell that, oh, would you look at that? This guy was able to, this participant was able to take this question and use it, and in fact, build momentum from it. So how do you suggest retaining? How do I suggest retaining or returning? Well, preparation. You need to know the ins and outs of your argument. So much so that when a question comes your way, you will be able to address it from whatever angle necessary, that you will be able to pivot from that point to the next point that you want to make. Can I shed some light on tips for written submissions? Well, again, written submissions is a different ballgame from the oral presentation. The written presentation gives a lot more room for a doctrinal approach. It has its own language as a legal memorial, so you need to stick with that legalese. But again, I think one of the rules that applies equally to the oral presentation or the written work is clarity. You need to ensure that the point that you are making is clear. Another tip, another point of advice when it comes to the written submission is your citations. Oftentimes, we rely and we make the mistake of treating every doctrine as the same. And I remember in one of my, and I think that isn't wholly incorrect after all. I mean, in the legal game, whether you're citing a doctrine from a 2019 case or a doctrine from the 1950s, if it's of legal effect, then it's of legal effect. It isn't quite the same thing when it comes to written memorials, because the checker will be looking as well whether you are familiar with the most recent case law. So it may be wise to cite more recent cases when it comes to your written submission. We have a question here. How do you shorten your oral pleading, deal with time restraints, and remain calm during questions? And forgive me if this answer doesn't truly help, but it's, well, practice. It's by simulating the debate. And I remember during my Oxford Price moot, we would each do at least 4 to 5 presentations a day, which I must admit was a bit too much. It came to a point that we lessened it to maybe 2, at times 3, so that we would be used to facing questions. We would be used to having to address a question, then get back to our point. And by simulating that, we are able to, well, work with the demands of time as well. We have here a question from Tianzhou Yang. May I ask questions regarding the rules? Do oralists need to present for both sides to be qualified to be best oralist? Well, unfortunately, I can't touch on that, but perhaps you could forward the organizing committee, forward your questions to the organizing committee. How can one move from the written speech to free navigation? Well, again, this is actually related to the question forwarded earlier, because it was forwarded by the same person. Again, practice. It is familiarity with your doctrine, familiarity with the case, especially with the facts of the case. And allow me to emphasize that the use of the facts is especially appreciated by the judge. That you are able to, well, first of all, use what you have already prepared and flip it around, let it take whatever shape or form, and still be comfortable with it. As compared to having a mere facial understanding of the presentation, a facial understanding of the arguments that you are forwarding, in which case you will understand it, well, in only one way. But when you've simulated this enough, when you've read the doctrines enough, when you've read the case enough, I remember during the Asia Pacific regionals, our team captain had gave us a very simple tip. He said, well, read the case at least twice a day, once before you sleep. And he wasn't asking us to memorize the case, but he was just saying, no, there is a substantive effect to the frequency. You read this enough times, it will stick. Much in the same way that if you simulate and prepare enough times, what would otherwise been a rigid recitation of your prepared speech, all of a sudden would come naturally. All of a sudden would be fluid. There's really no other way around it. It may seem like a very cut and dry, very corny, very generic answer. Oh, practice makes perfect. I've heard that before. Well, that's because it's, well, true. It works. Next, how should we approach the situation where a judge keeps insisting on a particular topic? And we end up having 3 minutes left to completely address the last issue. You only have one choice, really, to address that issue. And if you are to your wit's end, then tell the judge, that is my answer, and respectfully ask if you can proceed. No judge, no self-respecting judge would exhaust your time and deprive you of an opportunity to elaborate further just because the judge, he or she herself, is particularly interested in a point. In such a situation, even their fellow judges might intervene. And I've actually seen that happen in other moot courts where a fellow panelist would say, oh, okay, perhaps we should allow them to continue because, well, it isn't fair. And quite frankly, it isn't very professional to insist on a particular point. But with that said, the worst thing that you could do is, well, show your frustration with the judge, to fight the judge. That isn't your job. That isn't your role. And secondly, to guess, to give an answer that, and it's very quite obvious when an answer is given and there is no basis. And when they ask you, what's your basis? And you have nothing, again, that is a moment in the competition where the judges will, and I assure you, will look down on their paper and scribble something. It may be a note. It may be an X. Why? Because they need to leave a mark. Because such a situation does leave a mark when you make an argument without the legal basis. So address the question, and if having addressed it, you're unable to move forward, then mention that to the judge. Inform them that that's your answer and you would like to proceed. And above all, do not invent. Do not invent a doctrine. Do not invent an argument. We have another question. Presenting online before a camera is quite different from presenting offline. Very much true. Do you think, regarding the manner, it is better to have gestures like moving hands to show sentiment, or stay still before the camera to be less distracting? If you're a panelist, what's your preference? I would suggest against the hand gestures. Keep it at a minimum. You want them to be focused on you, on your 2x2, and on your arguments. And these hand gestures that I'm making right now, well, that's a luxury that I have as the presenter in this master class, but the rules are quite different in the moot court presentation itself. You want to stay calm. You want to stay not still in the sense that it's rigid and unmoving. You do want to appear relaxed as well, but you don't want to distract. And oftentimes having these hand gestures may distract. I recall one of my team members at the time, she was new, and she wanted to signpost. And when she presented, and this was live, she presented her first, second, and third argument, but her hands were shaking. And when we received the comments from the panelists, it said hands were clearly shaking. If she's nervous, best to stick within their own strengths. And when I read that, I didn't fault her for using the hand gesture. But what I did know was that it was an opportunity lost, in the sense that the judge, rather than using that space to comment and to reflect on something substantive, 2 sentences were used in saying, oh, your hands were shaky. It was, in so many words, a distraction. So avoid distracting the judge. We have an interesting question here. I think it's better addressed to the organizing committee, but I'll just read it out loud to highlight it. Does the Price Moot allow or encourage informal pre-competitions between teams for friendship and improvement? Again, I'm in no position to address that, but I'm highlighting that in case anyone would like to address it.
Thank you, Raphael. I've addressed it in the chat quickly. by
Oh, I
saying,
see. Okay.
by saying that pre-moots are not encouraged this year, given the circumstances of inequality in the participants across the world in accessing the internet and in being able to actually find a way to sort of get online without problems. And then some participants are in the same place and some of them are not. So it's all very complicated and we're trying to keep it as simple as possible. So we're not encouraging pre-moots. And I suppose what we would say now is that we aren't allowing them either. We will consider for next year's competition whether this is something that we would allow. I hope this clarifies it for everyone who's listening. Raphael, please proceed with the rest of the questions if you have the time. I just wanted to let participants know that we will be closing the possibility of raising questions in 5 minutes. So get your questions in as soon as possible.
Okay, yeah, thanks so much, Sonia. And yeah, I have some time, so I can just go through these questions. It won't be a problem. Maybe I'm not sure how many there are. I could perhaps go through maybe 5 more questions if that's all right.
That works. Yeah, please go ahead. Thanks, Raphael.
Okay. Sure, of course, Sonia. So we have one here. Which speech is more impactful? A flowery speech made beautifully, using a superior level of words to say, or a speech which includes less complex words, but relies more on legalities, citations? Now, again, this may seem like an obvious answer, but it's really a matter of striking a balance between the two. The rigidness of law does have its strength. And of course, the poetry of presentation is likewise well pleasing to the ear. And if you're communicating something, it may be of help. But at the same time, I mean, if you're not here to present Shakespeare, you're here to present a legal argument. So it's a matter of finding a balance between the two. But what I will remind you in addressing this question is this. Whether you so choose to explore a more flowery and creative way of presenting, or whether you rely on a more Article 5, Section 5 approach to the law, which again has its strengths, not my cup of tea, but does have its strengths. Do not sacrifice on clarity. I mean, oftentimes we are so concerned, and there may be times where we are concerned with whether something is presented in such a way that it is, well, creative and appreciated enough. And we are distracted from what is most important, from it being understood in the first place. So if you think that citing Shakespeare may be of assistance, and indeed, at times it has been for my own, in my own experience, I have cited Shakespeare in an argument here and there, and it did work out. The only reason it did was it did not distract from the point that I was making. It illustrated it. The line was, "A rose by any other name would smell as sweet," and we were pretty much arguing what's in a name. It was an argument on fair labeling, the principle of fair labeling. So again, feel free to get creative, feel free to get technical, so long as you do not sacrifice on clarity. Clarity is key. A little bit more on clarity. This relates directly with the pace. Again, this isn't a matter of stuffing your presentation with as many citations as possible, with as many doctrines as possible. Because if that were the function, then you should have, again, just emailed your argument with bullet points and made that point clear. No, you want it to be appreciated. And there's a fine nuance there. So when you're running out of time, don't rush. You are better off dropping an argument than being able to forward all the arguments that you wanted to present, but having to rush through them. I mean, keep in mind, all it takes is one argument to win the debate. You give a strong enough one, and then that's all you need. What is a strategy to confront a situation where the opposite side raises a convincing case, but you have not read it? Well, first of all, the best way to address this is, well, preparation. Read as much as possible. And honestly, if you've reached the point, and if you reach the quarterfinals or the semifinals or the finals, I highly doubt this would be an issue. You've got this far precisely because you are prepared and that level of preparation is recognized. But what if they, in so many words, forward an argument that you're not prepared for? Well, first of all, search through your mind, get creative, and find an argument that may one way or another address it. You may not be able to hit it out of the park, but if the best you can do is weaken it, then that may be good enough. If the best you can do is put it into question only enough to invoke a presumption in your favor, then that would be enough. Yeah, I've already addressed that. Does a quality oral submission necessitate covering all the issues one is supposed to cover? What if time restraints allow you to present only one or two issues? Well, I've touched on this earlier. Time constraints will, I'm letting you know right now, will have you pick and choose. And that's why we explored earlier the question of the matter of priority. You need to prioritize the arguments that work in your favor best. And the goal, again, isn't to flood the judges with doctrine. So for example, to make things a bit more tangible, when dealing with the three-part test, and there's a question as to whether this was provided by law, oftentimes that will be the case. And I mean, of course, we can, as we already know, what is provided by law is not only a question of text, but a question of quality, clarity, foreseeability, and these are things that may be addressed. But if in the end, the contentious matter is in fact the issue of necessity, then address the as provided by law, address the first tier of the three-part test briefly, get it out of the way, and address the matter that the debate actually comes down to. It is, again, a question of picking and choosing. There's one very interesting question here, and I think this is our last question. Can we use real-life news reports or results of empirical researches instead of cases to support our points or to illustrate a situation? Now, as you already know, Oxford Price has its own rules, and within those rules, there is the applicable law. So you would need to play within these rules when forwarding your arguments. But I think it's a different matter altogether if it's a matter of illustration. And this applies not only to the facts on the ground, but to domestic legal frameworks as well. As we know, this is an international moot. The sources of law are international or regional sources. But that is not to say that the trenches have no role in this. And what I often advise is, of course, to rely on the primary sources as much as possible. But if there is a need to rely on external, secondary or tertiary sources, then do so only as matters of illustration, to illustrate your point. You're not invoking it as a matter of law per se, but you are invoking it to illustrate, to paint a picture, to clarify your primary sourced argument. So again, it's a matter of strategy. It's a matter of picking and choosing how to do so. And if the rules have already identified which sources should be relied on, then clearly those should be highlighted in your arguments as well. So yeah, I think that is the last question that we have, isn't it, Sonia? So yeah, so thank you so much for your very good questions. And I wish everyone here the best of luck in the competition that is forthcoming. I have no doubt that everyone will do amazingly. And to the many of you, well, I look forward to meeting you. Perhaps I'll have the great pleasure of judging one of your rounds, and I greatly look forward to it.